Okay, Heartland Defender here yet again. The other big win we had this week was on a motion to suppress in a DUI case. A lot of times the client will ask me, what's a motion to suppress? Like, they know vaguely it's a motion, it's asking for something to defend them, but the nature of the relief is sometimes a mystery. And what a suppression motion is calling for is for the judge to declare that the evidence that was collected cannot be introduced because of some sort of improper law enforcement activity. A lot of times we're asking for a suppression where the client's constitutional rights were violated, as opposed to a motion in limine to exclude testimony, where we're trying to say that, or not testimony, evidence, where we're trying to say the evidence or testimony should be excluded because it's either irrelevant or it's really bad for us and we don't want it to come in. But suppression motion, it's based on a constitutional violation. And so when we have a DUI case, one of the main things we're looking at before we get to anything else is this stop legal? If the stop is legal, then did the officer have reasonable suspicion to believe a crime was being committed to escalate into a DUI investigation? And if that standard can be met, then we have to look at, over the course of that investigation, did the officer collect enough evidence to develop probable cause? So those are the three fracture points in a traffic stop that becomes a DUI. The other thing that could happen sometimes in a DUI is everything else was otherwise all right, but the officer didn't read Miranda and questioned my client. Then we'd ask to suppress the statements because certainly if there's already enough evidence in the case to damn us, we don't want our statements crammed back down our throats as well. Now, a brief word on motions to suppress statements and Miranda. I hear this all the time. They didn't read me Miranda. This case is going to be open and shut. They can't prosecute me because they didn't read Miranda. No, that's bullshit. Miranda becomes important to protect you from self-incrimination. It's not an easy get out of jail free card. It's a guarantee that you will not be compelled to incriminate yourself. So when does Miranda kick in? Miranda kicks in when you are in custody. In other words, you're not free to leave. And the officer starts asking you questions. Not just any questions, questions that are designed to elicit an incriminating response. How much have you had to drink tonight? Where are you going? Are you on any medication? None of these are meant to rule out the DUI. They're not meant to help you. They are meant to incriminate you. So where these questions are asked with the sole purpose, with the express purpose of incriminating you, and Miranda is not read, then that becomes important. Then you've got a Fifth Amendment violation and we can try to suppress your statements. So now that we talked about the various fracture points in a DUI stop and where we can try to attack it for suppression purposes, what do we do with that? What are we saying? Well, we tell the court, and we have to lay it out pretty explicitly, law enforcement committed this illegal activity or acted in an illegal way. Law enforcement collected X evidence as a result of that illegal activity. It was illegal because of X, Y, Z, and therefore it should be suppressed. What are we seeking to suppress? Fucking everything. If I can, I want to suppress everything. If I file a motion to suppress, I want the observations after the stop to be suppressed. I want every observation while the person is asked out of the car suppressed. I want field sobriety suppressed. I want questioning suppressed. Videos, body cams, dash cams, the request for a breathalyzer, the results of the breathalyzer, or if there was a refusal, the request and the refusal. I want all of that suppressed because once we've got some illegal activity, I want to kick out as much as we can. And why does stuff get kicked out even if it's multiple steps removed in the process? Because of the fruit of the poisonous tree. I mentioned that in one of the previous videos. The fruit of the poisonous tree basically says it doesn't matter which apple you pick off the tree, they're all poison because this entire tree is poison. Why is this tree poison? Because of the illegal or unconstitutional activity by law enforcement. So, was the stop legal? If the stop was illegal, everything that flows from it goes away. Was the stop legal, but there was no reasonable suspicion to investigate for DUI? Then everything from that point we try to suppress. Possibly a driving pattern, if any, would still come out. The initial observation, any alcohol, anything that was observed by the cop before they have the person step out of the vehicle, at that point would be suppressed. Everything after that point, fruit of the poisonous tree. Let's say they have PC to stop. It's justified. They're justified in asking you out of the car. They're justified in conducting that DUI investigation. Then we're looking at, is there probable cause to arrest for DUI? And arresting for a DUI, at least from the defense attorney's reading of the case law, is not just, hey, I smelled alcohol, therefore this guy's drunk, we're going to arrest him. No, the officer cannot arrest merely for the smell of alcohol or the admission of alcohol. The officer has to find that the person was driving while impaired to the point that their normal faculties were not working as they should, or that the blood alcohol level was over 0.08. So there has to be an investigation built up. This is typically what they call the phase 3 of the investigation, where they're observing you outside of the vehicle. How do you stand? How do you walk? How do you talk? How do you perform on these field sobriety exercises? If the sum of the totality of those circumstances shows that, yeah, maybe the guy wasn't okay, but maybe he was sleepy, maybe there was some other reason for his impairment, then we can argue that the officer did not have probable cause to arrest for DUI, and then everything from that point gets suppressed as fruit of the poisonous tree, and on and on and on. As we whittle things down, depends on where we can find a suppressible point. That's where the evidence starts to get suppressed from there on as a fruit of the poisonous tree. Lastly, if there's a good stop, a good escalation to a DUI investigation, and PC to arrest, well, at that point, we're going to have to argue the strength of the evidence. We won't be able to ask for a suppression. But if there wasn't a good probable cause determination, then also that request for the breathalyzer is illegal. To ask for a breathalyzer, you've got to have probable cause to arrest for the DUI. If there's no probable cause to arrest for the DUI, you can't request it, and the breathalyzer itself should be suppressible, or the refusal should be suppressible. So the next part of this video, let's talk about the case that we scored a big win on last week. So in that case, my client was arrested for DUI. He was called in by some third party at some business that reported a drunk driver. My client, for the record, was not drunk. He was massively sleep deprived. He did not have slurred words. He had a very thick Hispanic accent. But that we're not there yet. The main issue here, as I filed my motion to suppress, is the fact that a third party called it in, and there's certain standards we have to meet if the officer is not the one that initiated the DUI investigation or DUI suspicion. If a third party calls it in, that's an anonymous tipster. If we don't know who that person is, what they're doing, why they called, where they went, who the hell they are now, where they are, that's an anonymous tipster. An anonymous tipster is not particularly reliable. So before an officer can stop someone based on a tip from an anonymous tipster, the officer has to make some corroborating observations on their own and talk to the person that called to get some corroboration. Now, if the person was a citizen informant, hey, my name is Joe Concepcion, I live in Sebring, I work at this place, I saw a drunk driver and I want to report it, here's my phone number, call me back if you need anything else from me, then that's a citizen informant, and they're going to be clothed with a little more reliability. But that's not what we had in this case. In this case, we had someone who was an employee at a business tell their manager calls it in. To this day, I don't know who the hell that employee was or who first made the observation. But that manager calls it in, the police swarm in, they box my client in, there's about 4 vehicles on the video, and they immediately proceed to conduct the DUI investigation. Ask the client out of the car, start asking for field sobriety exercises, where you been, where you going, what you've been drinking. At no point, though, did any of those officers stop to corroborate and speak to the manager to find out why the call was made and get some corroboration. They also didn't see any driving pattern since they boxed my client the moment he started moving his car or the moment he had parked his car. So without any corroboration, that entire stop is illegal. This DUI investigation is going to go belly up from the get-go. So in this case, we argue the stop is illegal. And what did we say about the fruit of the poisonous tree? Everything after that stop is illegal. But for good measure, I argue the stop is illegal. Even if the stop was deemed legal, even if the detention was somehow deemed legal, asking him out of the car and beginning a DUI investigation was not legal because there was not reasonable suspicion. Even if they had reasonable suspicion, based on the totality of the minimal investigation they made, there was no probable cause to arrest. So what happens when I file the motion? I have to make that allegation that there was a constitutional violation and that any evidence that was taken as a result is suppressible. And at that point, I've got the burden of a prima facie showing of the constitutional violation. That can be satisfied by the allegations of the motion and by letting the court know or asking the court for judicial notice of the court file, which means the court takes notice of its own court file to determine there is no warrant for the client's arrest. It being a warrantless search and seizure, the burden then shifts to the state. At that point, the state has to prove that the stop was legal, that there was cause for investigation, that there was probable cause for the DUI arrest, etc. And the next part of this is a cautionary tale on why in all my 26 years, I don't do scripts. I prepare for my case. I know my law cold. I know my facts cold, but I don't prepare scripts. Sometimes I prepare an outline of questions and points I want to make. Other times I don't. I just know where I want to go. Because if you have a script and things go off script, then what do you do if you've become too reliant on that script? You're left with your pants down. And that's kind of what happened in this case, and it's happened so many times at trials. Things don't go exactly how I want them to. They go how I might think they're going to. And because of being able to kind of react on the fly, almost a preparation on the feels, if you would, that allows me to react to things that would be unexpected. So the unexpected turn in this case was there was no officer. There was no witness. The state decided to proceed solely on the DUI investigation video, the body cam of some other officer. Now, first of all, I don't know how this establishes the legality of the stop, but the bigger issue for me is you can't just put evidence in. And so we're going to segue and talk about evidence here. What is evidence? A lot of times people talk about evidence. They don't have any evidence against me. They don't have any photos, any video, any surveillance. All they have is this person's word, and that's hearsay. Well, first of all, that's not hearsay. Hearsay is a statement by a declarant outside of the courtroom for the truth of the matter asserted. A person that comes into court is not a declarant outside the courtroom. They are a witness. Their testimony, if believable, is evidence. So photos, videos, evidence, surveillance, all of those things are tangible evidence. Testimony is also evidence. At the very least, you need testimony from the officer that this is why they conducted the stop, this is why they had reasonable suspicion, this is how they developed their probable cause. Without an officer testifying, how do you establish any of that? So, over objection, the court humored the state and let them present their video, which was about 5 minutes of the officer pontificating and jumping to conclusions. Interestingly, if we were to get a transcript, the appellate court would probably not be able to tell what in the world was said on that video because of traffic noise. But the state wanted to present that as their proof that there was a valid reason for the stop. Now, I pounded the table, I pounded the law. You cannot just introduce a video. I can't give the court a video or a picture. It just doesn't work that way. I need a witness that authenticates the piece of evidence that I'm looking to introduce, and that includes photos and videos. Even in the case of what's called a silent witness theory, where video is introduced by somebody who didn't actually take the video, but they operate the machinery that took the video, even then you've got to have someone to authenticate the video. So there I am, caught with my pants down. I've got all these great arguments I want to make as to why the traffic stop is bad, why the DUI arrest was incomplete. But if I lean too strongly into my arguments, I'm going to legitimize what the state had just done. So now I've got to figure out, no, how am I going to make this argument? I'm going to harp on the lack of authentication and the fact that by not having a witness testify, the state has not established anything. And if the state has not established anything, how in the world do they carry their burden of proof? So in such a case, what would happen? My argument is that the state's failure to introduce any testimony authenticating the evidence renders the evidence inadmissible, and therefore the state, what are they left with? Nothing. Without anything, that means they didn't meet their burden. They didn't meet their burden. That entitles us to suppression. Suppression means the state has no evidence. No evidence means no case. No case means my client wins. As I said, the state was humored by the judge when we were asked to submit briefs. And this is another thing that one should be prepared for. Sometimes you're not going to get to make your arguments. Kind of like the motion to suppress. I didn't get my ruling that day. Judge wanted me to do more work. And so not only do you have to be a good preparer, you don't have to just be a good speaker and a good orator. You also have to be prepared to go back and do more research and be a good writer. Fortunately, I wrote a good brief. The court reconsidered the admissibility of the video and asked me to submit an order granting the suppression. And now we just wait for the state to file their dismissal, because at this point, with all of the evidence suppressed as fruit of the poisonous tree, they have no case.